This child was planned. All of a sudden, me and her were in a relationship, and the next thing you know, I give her money and I give her a vehicle, and she's gone.
My understanding is that Mr. Bowden is requesting a continuance. The state has no objection. We just asked that if it's granted, that July 22nd be the reset date. I believe that works with both of the parties.
No.
That is correct, Judge. I filed a motion for continuance. Mr. Pender, who is no longer with our office, was previously on this case for Ms. McDaniel. I just recently took over and just need a little bit of time before we have a contested hearing on the merits of this case. And so we had filed a motion for continuance. I think we never got a response from Mr. Bullard about whether he agreed or disagreed. My understanding is he does not agree to a continuance, but I'm just asking for, like Mr. Diamond said, we got July 22nd as a date from your court coordinator. I'm available. That's our request for this morning, Judge.
All right, then, Mr. Bullard, it's kind of pro forma. When a new attorney comes on a case, the court gives them time to get up to speed. It's kind of malpractice for me not to allow them to do that. Well, their malpractice, yeah. But the bottom line is, sir, what's your objection at this time, sir?
Sir, I've been waiting for 5 years for this child. This child was planned. All of a sudden, me and her were in a relationship, and the next thing you know, I give her money and I give her a vehicle, and she's gone. I never seen the child. I've been looking for the child for four and a half years now, and I've been doing through all the court system. And so I'm asking for today it to be resolved to where at least I can see my child.
All right, well, again, sir, we're talking about less than a little bit more than a month. I don't think it's going to make that much difference after 4 years. I understand your impatience, sir, but the bottom line is, it's just pro forma that the court, this is the first continuance. This is just what the law does, sir. If you came into me next month and asked for a continuance for your lawyer, I would grant that. Okay, that's just the way it normally works, sir. Again, I know you're not a lawyer, but what you're requesting the court to do is purely personal, and I understand there's some time frames involved, but obviously, it sounds like this matter is going to. Is this matter contested, or because it sounds like that? What's at issue? Because again, sir, are you asking for something other than visitation and the obligation to pay child support, or what are you asking for?
That's what I want. I want rights to my child. I have a 10-year-old, and I have 50% of her, and I want 50% of this child, and he's my child. It's proven already.
Here's this, sir. You sir, honestly, Texas doesn't have 50%. Okay, we don't do that. All right.
Okay. Well, I think I get. All right, then I got the more of it. Whatever's going on with this one, I got the more of it.
You know, this is not a 50-50 state. This comes up all the time. I just want to let you know that up front.
Yes, sir.
I'm going to continue. It's just pro forma. I'm sorry.
Judge, 5 years?
Sir, do not argue with me. The continuance is granted, sir. 22nd, that's a normal court date?
Yes, sir, Your Honor.
All right. I'm gonna go ahead and, like I say, sir, I'm granting the continuance. I'm resetting it 1 month, sir. And Mr. Bullard, you throw something else down like that, I will hold you in contempt.
Oh no, sir. I wasn't meaning to do, sir. I was just putting my Bible down. Sorry about that. I'm not even upset, Judge. It's just shocking to me that somebody has to wait this long. I'm not upset or anything, Judge. It's just very shocking to me.
We're going to get this one taken care of, sir. But again, I got to give the lawyer the opportunity to get up to speed of the case, and that way we can make it a final order instead of making it temporary. All right.
That's fine, Judge. Thank you. I didn't mean to do none of that. Okay. Thank you, Judge.
All right. Yeah, sometimes I misread what people do. You know, I don't.
Judge. No, I just want to see him so bad, Judge. It's 5 years, and it's just that I didn't. It's okay. All right, I can wait another month, Judge.
All right. Thank you, then, sir. And
thank
again,
you, sir.
We'll set it up, and obviously, Boudin will. I'm sorry, I just named you after Sacha. Sorry about that. Anyway, we'll go ahead and get it all set up, and we'll see you on the 22nd, ready to rock and roll, and get this gentleman some time with his child. Obviously, if you got something that you're requesting based on the facts, sir, we'll take that up at that time. But we'll see what you got and see what mom has, and we'll take it from there. Thank you.
Yes, sir.
Thank
you, sir. Thank you, Your Honor.
Okay, no problem, sir. Again, I've got my apologies, but yeah, we'll get this taken care of, and I'll write my notes up on this one. Thank you, sir.
I can wait that. No problem. Thank you, sir.
Thank you.
All right, bye-bye.
So the state is requesting a final order here. The non-custodial parent was here and apparently left. But the state's numbers are going to be based upon $15 an hour. So state's looking to set a child support of $428, a medical support of $117, and a retro for the last 2 years of $10,272, with repayments set at $110 per month. The state is also of the understanding that there are some safety concerns, hence the ad litem, and related to potential drug use. So state's asking for the appropriate ruling there of when it comes to the access and possession of the dependent.
All right then, Ms. Adlida.
Yes, Your Honor. I'm also requesting that we proceed in default today. The father was here earlier, spoke with him, and he essentially was upset about some things and decided he was going to leave. So I'm asking to proceed in default. I will be asking today for the court to appoint the mother's sole managing conservator and to appoint the father possessory conservator. I will be, the evidence is going to show that this is going to be in the child's best interest. In addition, I'd be asking the court today to make orders with regard to what father's possession and access should be. I would recommend to the court that they remain what they are in the temporary order. In the alternative, if the court wants to do something different, I would ask that the court consider making his periods of possession of any continuously supervised. Evidence will show today there's concern for father's behaviors and potential drug use, and also his refusal to comply with the request for a hair follicle drug test. And child support as per what the request.
All right, well, that's prima facie right there that, yeah, that there's a problem. When somebody refused to take the test, then yeah, they'll work for the court every time. But let's get some testimony on that. Let's get some background on that. And let's get some, something that I can hang my hat on and make a final order. But it sounds like everything y'all are requesting is appropriate. But let me get the testimony to back it up. So at this time, I'm going to go ahead and ask that Ms. Cox unmute herself and raise her right hand, and we'll get started. There you go. All right,
Yes.
Ms. Cox, you solemnly swear or affirm any testimony you're going to give here today is the truth, the whole truth, and nothing but the truth, so help you.
Yes, sir.
All right, ma'am, you're officially on the oath, and you can put your hand down. I'll let the state call you as a witness. The ad litem's going to cross-examine. If there's anything at the end of the hearing you think I need to know that didn't come out because you don't have a lawyer representing you, you're your own pro se representative, so you can tell the court anything else in addition you think I need to know. But at this time, I'll let the state go ahead and call you as a witness, and we'll proceed. Thank you.
Okay.
They would like to call Aubrey Cox.
Yes, sir.
Please state your full name for the record.
Aubrey Rose Cox.
And what is the name of the child that we are here on?
Maverick Maxey.
Alrighty, and that's the only child of this relationship?
Yes.
Okay. And how's that child that child is currently receiving government medical, correct?
Yes, sir.
For insurance? Okay. And Ms. Cox, are you aware of what Mr. Maxey does for a living?
I know he claims to be self-employed. I think he just kind of does what he can when it's available. But it's along the lines of like construction and handyman. I know his last job that he had mentioned, he was remodeling an entire kitchen. So
Okay. So are you aware of how much he makes?
I've never known him to work for less than $15 an hour.
And he works full time, correct, at what he does?
Yes.
Okay. So then I also understand there might be some safety concerns when it comes to the access and possession of the dependent. Is that correct?
Yes, sir.
Okay. And why are there safety concerns?
My son's father has a drug problem. It's been off and off the entire time that I've known him. Right now it's very on.
Okay.
So.
And have you submitted a hair follicle test?
Yes, sir.
Okay. And are you aware of whether or not the father of the child has submitted to any sort of drug test?
No, as a matter of fact, he's told me on multiple occasions he's absolutely not going to take it.
Okay. For the time being, I apologize. I do have one more thing.
Mhm.
You are requesting retroactive child support, correct?
Yes, sir.
And to give some credit for support that was provided, you're only requesting that that be set for the past 2 years, correct?
Yeah, just because I can't put an exact number on the money he has given me because it's come through different channels every single time. So
Okay.
just to kind of be fair.
Yeah. So you heard the numbers of the state
And can you give me those
provided.
numbers again, please, Mr. Gwynn? Thank you.
I'm so sorry, Judge, I didn't hear you.
Can you give me those numbers again, please?
Okay. So you heard that with one child in and no child out, that the state's calculations were $117 for medical support, $428 for child support, and then a retroactive payment for 2 years set at $10,272 with monthly repayments set at $110 per month.
Thank you.
Yes.
And you are in agreement with those numbers that the state provided?
Yes, sir.
All right, thank you. State has no further questions of this witness at this time, Judge.
All right, thank you very much. Mr. Garcia, you're a witness.
Yes, ma'am. And since this temporary order, there was a temporary put in place recently, correct?
Yes, ma'am.
Since that temporary order, has the father paid any of the support he was ordered to pay?
He sent me $5 last week for my son.
Okay. And has he provided any necessaries or anything like that in addition to the $5?
No, ma'am.
All right. And has he completed some visitations?
He's seen my son in person twice. One time was actually just this last weekend. I took my son over to his grandparents so that they could go swimming. And that was just for like an hour or two. And then the time before that, it was the same scenario. I took my son over to his grandmother's house, which is his father or his mom and dad's house.
Yes.
And he actually tried to physically remove my son from the home, and it was like a big knockdown, drag out argument in front of my children. 'Cause he
Okay.
was trying.
And just to clarify, that knockout, drag out argument was between his parents, the grandparents, and him, correct?
Yes, because his parents, I mean, they love him, that's their son, but they fully understand it's not the best situation for their grandson either, and they didn't want that to take place while it was on their watch. So
Perfect. And so it's my understanding that the grandmother actually reached out to you on the phone while this was going on.
yes, ma'am.
So you were able to kind of firsthand hear uh,
Mhm.
the way of acting, correct?
Yes, ma'am.
All right. And how would you describe his behavior that day?
Very erratic, very aggressive, a lot of swearing, a lot of threats being made to his own parents. He tried to physically take the car seat that my son's grandma keeps in her vehicle, so that he could take my son. Um, and it was just not good. Both my kids were screaming and crying in the background. So
Okay. Um, is this the type of behavior that you know him to display in the past?
yes, ma'am. Whenever he doesn't get his way or he feels like he's not in control of the situation, he tends to get pretty upset.
Do you also have concerns that for his drug use?
Yes, ma'am.
Does he have a history of drug use and drug charges?
Yes, ma'am. He still has an ongoing case in Bell County that he just actually had his bond revoked and they arrested him for it and then he bonded out again. So,
Are you referring to the possession of marijuana case that he recently got charged with?
yes, ma'am.
Okay. But to that, he's got some felony history. He's actually been in prison and he's been on parole, correct?
Yes, ma'am. I'm sorry. Could you?
Yeah, she's cracking up. You're cracking up, Mel.
Can you hear me now?
Yes, ma'am.
Okay, maybe it's the coverage. I was asking if those felony charges and his previous felony history, is that all related to drugs as well?
For the most part, even if it was like one of his charges is burglary of a habitation, I don't believe he would have done that if he wasn't on drugs. So I would say yes.
Okay. In the history and the time that you've known him firsthand, you know that he uses drugs, correct?
Yes, ma'am.
What type of drugs does he use that you know of?
Methamphetamine and marijuana.
Okay. I, whenever I was appointed, I asked both you and him to take hair follicle drug tests for the court. Is that correct?
Yes, ma'am.
And you actually took yours and submitted it to me, and those results were all completely negative, correct?
Yes, ma'am.
The father, and you're aware that he did not submit any drug test. Did you and him have a conversation about that?
Yes, ma'am. We've had a few. Because on
What
the
did he
first
tell
court
you
meeting,
about
he told me he's not going to take it. Um, the first time he just absolutely refused. He said, "LOL, I'm not doing it." And then actually a couple weeks ago, I had mentioned it again. Because every once in a while he'll start a little argument, and I told him like, look, if you want to see your son, all you have to do is comply with what the court is asking of you. You just need to take the drug test. And he said, I'll take a urine, but I'm not taking a hair follicle. And yeah, but he didn't mention that either. So I just believe he doesn't want to take one.
Okay. Do you believe he doesn't want to take one because he's probably going to be positive?
Yes, ma'am.
All right. And so he hasn't been very consistent in maintaining contact with the child, has he?
No, ma'am. I know he was supposed to get a video visit every Wednesday and Sunday. And pretty much the entire time since our last court date, he's had me blocked on the phone, so my son can't even call him, even if he wants to.
Do you believe that if the court were to keep the visitation provision that's in the temporary order and make that a final order, do you think that that would be in the best interest of the child?
As of right now, yes, I do.
In the alternative, if the court wants to do something else, would you ask the court that those visits, any visits that he has with the child, be supervised by his parents?
Yes, ma'am. Either his parents and then his aunt and uncle actually live across the street from his parents' house. And they said if for whatever reason his parents are unavailable, that they would fill in.
Okay. Um, all right. And has he ever mentioned to you that he owns a business? Is that how he refers to his work, or how does he refer to his work?
I mean, yes, he says he owns a business, but I mean, he doesn't have any type of like licensing, or he just made a logo and he has a business.
Okay. And that's the work that you were referring to earlier, where he does remodeling and of sorts?
Yes, ma'am.
Okay. All right, I pass the witness.
All right, anything else on redirect, Mr. Glenn?
State has nothing else, Judge.
All right, ma'am, I'm looking at granting everything that the state and the ad litem are requesting. Obviously, the court has some serious concerns about this gentleman. So I'm looking at naming you sole managing conservator. I'm going to give you the right to decide domicile. I'm going to make that right unrestricted. I'm going to name him as possessory, but based on the fact he's still got current charges pending for drugs, he refused to take the drug testing as ordered by this court is prima facie. The reason is because he knows it's going to show that it is positive, and hair follicle goes back so far that he's really worried about it. So anyway, I'm going to go ahead and, like I say, name him as possessor conservator. I'm going to order him to pay child support, cash medical, and the retro as requested by the state, and the amounts as requested, giving him a fair and showing that you're only asking to go back 2 years to be fair to him, and the court will so grant. As far as the visitation package, ma'am, and ad litem, I'm looking at just letting at this point. I hate to leave it just up to mom, but the fact he's not here and the fact that I got no one to speak for him, it's kind of hard for me to make an order that's going to be truly enforceable without getting some input from him, because I don't want to make it something that mom has to plan ahead every time. You know, the first, third, and fifth Saturdays. I might just make it for any time that she agrees to, but fail an agreement, and upon notice, he would get the some time restricted on the first Saturdays of the month from 1 to 5, and the care of a third party that the mother agrees to, or as anything along those lines. Would the ad litem want that, or would the ad litem want something different than that? Or would the mother, ma'am, would you want something different than that?
I, as long as it's supervised, whether it's me or one of his family members, I mean, I don't
Well,
really
I'll make it
mind
you.
that.
But again, I wasn't sure if you wanted it to be you based on this gentleman's behavior, but I'll make it you, or or you can designate an agent to do a supervised visit. But right now, I'm probably looking at only doing one a month, and then he's got to give you at least 4 days advance notice that I'm sorry, let's make it a whole 7 days, because you got to find somebody to do it. And you could use his family. Obviously, they'll go toe to toe with him about protecting that baby. So yeah, I don't think you got to worry about what's there. Usually, it's just the exact opposite. But yeah, they know.
Yeah.
So I'm going to go ahead and look at making that until further order, court, the first Saturday of each month, or anytime else y'all can agree. But he has to give you at least 7 days advance notice that he wants to have his visitation, and you get to set up, would it be being with you or with a designated agent, and you'll get back with him at least 48 hours in advance, telling him where, when, and with who. Okay.
Okay.
All right. And everything, and I'm going to order him responsible for court costs on this one. He didn't show up. He's not. I'm going to order that he has to pay court costs, but I'll give him until the 30th of June of 2026 to pay that in full once billed by Lampasas County District Clerk. So, is there any? I'll start with you, ma'am. Do you have any questions? And then I'll go to the lawyers. Is there anything else I need to rule on? So at this time, ma'am, do you have any questions?
No, sir.
All right, Ms. Garcia, anything else, ma'am?
No, Your Honor.
Anything else?
No, Your Honor.
All right, then, Mr. Gwynn, anything else, sir?
I do have some questions for clarification for that access and possession order.
Yes,
So
sir.
it's going to be once a month. It's supervised by a third party, approved by mom. You set that at the first Saturday of the month. You required at least 7 days notice, and some of the other requirements state.
And it's by mom or a designated agent. Mom could do it, or she can use a designated agent. He's got to give it. It's the first Saturdays from 1 to 5, and he's got to give at least 7 days advance notice. Yes, sir. That he wants that first Saturday of the month. And
p.m. to 5
I
p.m.
gave mom the right, and mom, and he can agree to anything else, but the only court ordered portion will be that first Saturday of each month.
Okay.
Okay, court ordered Saturday, 1 to 5 p.m., 7 days notice. Was there any other notice requirement? I thought I had heard something
Yeah,
regarding
she has 48 hours to get back with him before the visitation on who and where and the place, who, what, and why, who, what, and where, as far as the visitation is concerned. So she's gonna let him know the location where he has to appear.
Okay, got that. Thank you, Judge. No further questions.
All right, then. All right, ma'am. I'm gonna go ahead and, like I say, set that up, and good luck to you and your child going forward. And you take care. All right, because somebody's got to be the responsible adult here. And right now, you are nominated and coronated and sworn in as such, ma'am. Okay, so take care.
Okay.
All right.
I'm trying. Thank you.
Yeah, because believe me, as soon as 13 hits, you're gonna have some fun.
I swear he's already got the mindset of a teenager. He's
There
something.
you go. All right, then. Thank you very much, ma'am. And we're off the record.
Thank you.
Requesting a final order. My understanding is that Ms. Gustafson's recommendation to the court is going to be to keep the current calculations in place, which are based off Mr. Calloway. He's a 100% disabled veteran, and I have no objection to that. So I believe the only issue that we're going to be contested on, although I'll ask Ms. Calloway some questions to that effect, but I believe the only issue is going to be the non-disclosure. The state is still requesting the court to order it out of an abundance of caution. But either way, I'm requesting a final order, whether the court orders it or not.
All right, Ms. Gustafson.
Yes, Your Honor. I believe the evidence will show that Mr. Calloway is receiving his VA income and is actively pursuing methods of trying to get additional income in. And then on the point of non-disclosure, I believe that came from really one incident, and being abundantly cautious, I would say that perhaps the court should consider non-disclosure, but I'd like to put some evidence on just so the court could
All right.
consider that.
Was the original non-disclosure in the temporary order, or was it originally in the final order prior to the final order of the court prior to this?
It was not in the final order or the final divorce decree. These
Okay.
people were divorced in 2023, Your Honor.
Okay, good enough. Thank you. All right, then. So, Mr. and Ms. Calloway, you there? Need to turn on your videos, unmute yourself, and raise your right hands, please. All right, do you both solemnly swear or affirm the testimony you give here today is the truth and that but truth will help you?
Yes, sir.
Yes, sir.
All right, you're both officially on the oath. I'm going to go ahead and put your hands down. I'm going to let the state call you both as witnesses. At the end of the hearing, if either of you wish to make a closing statement, a closing argument, or tell the court something that didn't come out that you feel is pertinent, you'll be allowed to do so as your own rep. But this time, I'm going to let the state and their line call you as witnesses and get some testimony and see what we can do here as far as this order is concerned. Again, we're limited to the review the review of the child support review order. So let's see what we got. Thank you. And I'll go ahead and let Mr. Diamond call your first witness. Thank you.
Thank you, Your Honor. I will call Ms. Calloway. Ma'am, will you unmute and state your full name, please?
Sandra Calloway.
All right, so let's start off with the money. I believe the recommendation from Ms. Gustafson is going to be that to keep the child support where it is. That's based off of Mr. Calloway being 100% disabled. Do you have an objection to doing that?
No, I don't.
Okay. All right, I appreciate that. So let's move on to the non-disclosure. The state is still requesting the court to order that your address and contact information not be included in the final order. You agree or disagree with that?
I agree.
Okay. And begging your pardon, Your Honor, I believe she's testified to this previously. I can revisit that, or I can just ask her what's occurred since the last time we were in court. Does the court have a preference?
Just get her your own testimony. Let's put it anew this time. Thank you.
Thank you, Your Honor. All right, so let's talk about safety concerns. Do you have safety concerns with Mr. Calloway?
As long as he's not showing up at my house, not geared towards me, no.
Well, but that's the issue.
Yes.
You don't want him knowing where you live, is that correct?
My biggest thing is I don't want him showing up at my house unannounced. I've already told him multiple times I don't want him showing up, and he has continued to do that. But since the last hearing, he has not, that I know of.
Okay. So between when you were divorced and the last time we were in court, how many times would you say he showed up unannounced?
I can't remember.
I mean, is it so many times that you would need, say, more than a hand or two to count them?
Maybe a hand. Maybe. I don't remember completely.
Okay. Has he ever been physically violent with you?
When we were married, he had put his hands on me.
Okay. And since the divorce?
No.
Okay. All right. Has he made threats since the divorce?
Since the divorce, no.
All right. As far as his behavior, in your opinion, I'm going to ask you kind of a general question. I'll narrow it down if I need to. Would you say that his behavior towards you has been harassing?
Just
And
with
that
those texts we talked about last time, like with the videos and just making inappropriate comments. But other than that, towards me, no.
okay. Kind of generally, can you describe the types of videos that he sent you?
It was about sex, having orgasms, things like that.
Okay. And he's texted you, inquiring about your current relationship, things of that nature. Is that correct?
Yes.
Okay. When was the last time that he sent you a video that you found inappropriate or asked you about your current relationship?
I can't remember. I want to say sometime in January or February.
Okay. Um, when he showed up at your house unannounced the 5 or so times, were there acts that he engaged in that were inappropriate?
No, this last time was just pounding on my door really loud.
Okay. I will pass a witness, Your Honor.
All right, thank you very much. I'll let the ad litem have the witness at this time. Thank you.
Yes, Miss Calloway. The last time that Mr. Calloway came to your house, was it to drop off the insurance information for the children?
It was, but I told him that I would get it the next time I saw him. And then the next 20 minutes, he was already at my door.
Had he previously contacted you to try to drop that information off to you?
I don't remember, honestly. I couldn't tell you. I don't know.
So you don't recall if he had tried previously to try to get that information to you?
I can't remember.
Okay. And on that occasion, you said he knocked on your door loudly.
Yeah, I came up and the boys were and I were sitting on the couch and we heard the screen door swing open and then it was a loud thumping and we're like, what was that? Because we weren't expecting anyone. And then I looked out the window and it was him going to his car and leaving.
But he had left the boy's medical information, medical card
Yes.
for you. And was that
Yes.
something that he was ordered to do?
Yes. I had been asking for it for a while and I hadn't gotten it. So they told him this last go that I needed him.
And if Mr. Calloway uses the app close
Mhm.
app as he's ordered to do, would that rectify your concerns with the inappropriate text messages?
That's fine.
Okay. He currently does know where you live, correct?
Yes.
And y'all currently do the pickup and drop off of the children at your mother's house?
Yes, ma'am.
And he hasn't asked you to change that, is that right?
No, ma'am.
Okay. I'm sorry, I have to plug in my device. I apologize. Pass the witness, Your Honor.
All right, anything on redirect, Mr. Diamond?
Nothing else, Your Honor.
All right, thank you, ma'am. We'll be back in just a moment. Call your next witness, please, Mr. Diamond.
Mr. Calloway, sir, will you state your full name, please?
Todd Logan Calloway.
All right, so the same questions to you. So let's start with the money. My understanding is that Ms. Gustafson's recommending, and I'm in agreement with, setting your wages based off of the disability that you receive. Is that acceptable to you?
Yes, sir.
Okay. All right, let's move on to the non-disclosure. So I take it you would like to know, you would like everyone's information to be disclosed in the final order. Is that correct?
Excuse my ignorance. What exactly does disclose mean again?
Yeah,
Sorry.
yeah, it's a legal term of art. So in the temporary order, the court order made a finding for non-disclosure, which means, and it was a temporary finding, meaning that Ms. Calloway's information, her contact information, her residence, her email, phone number, were not to be disclosed in the order, so they're not published in the order. Um, so my understanding is it sounds like she's still requesting that. I don't know that this case is going to get there based off of the testimony, but the question is, my understanding was you were opposed. You want to know, you want to know where the children live. So, do I understand you correctly?
Yes, sir. That was for the future, like if she happens to remarry or whatnot, because they're still under 18, right? Um, and off it's just one past relationship, right? But besides that, that was the only reason why. But yes, sir.
Okay. Uh, Do you want to add anything to what she said as far as why the court should or should not order the non-disclosure? Okay.
Probably not. So like I said, it was just off one relationship of what she told me, and that was the reason why I wanted to know in the future where she lived at for
I
the safety of my kids, but that's about it.
I understand. And so if the court doesn't order the non-disclosure, would you still be okay doing pickup and drop off at her mother's place?
Oh yeah, I love her parents.
Okay. Um, all right. I appreciate that, Mr. Callaway. I'll pass a witness, Your Honor.
All right, Ms. Gustafson.
Yes, Mr. Callaway, you had requested that your child support be reduced, correct?
Yes, ma'am.
And everyone seems to be in agreement with that. But the change in your income was because you were a teacher at Coppers Cove Independent School District, correct?
Yes, ma'am.
But you weren't, and you're not a licensed teacher,
No, ma'am.
correct?
No,
And
ma'am.
so you have not set for that exam, and there's quite a bit to do for you to be able to do that. Is that right?
Yes, ma'am.
So at this point, you are now taking classes. Is that right?
Yes, ma'am.
And what are those classes in?
Appraisal.
So
Home
it-
appraising.
So it's your intent to become a home and land appraiser?
Light home appraising, and then probably commercial as well, like for commercial buildings.
And so it's your plan to complete these classes sometime maybe by the end of July, but you have got those scheduled to take. Is that right?
Yes, ma'am.
And then after you would do that, before you could actually take the licensing test, you have to complete 1,000 hours or 6 months with as an apprentice to an appraiser. Is that
Yes,
right?
ma'am. Yes,
But
ma'am.
that is what your intention is.
Yes, ma'am.
And in the meantime, you have been applying other places for a job.
Yes, ma'am.
So you're not just planning on living off of your VA benefits.
No, ma'am.
So you want the court to know that you are attempting to become and increase your income other than just your VA benefits.
Yes, ma'am.
The situation with having a non-disclosure, you would like to have a disclosure in the order because you're concerned that at some point in the future that mom might move away with the children and you would not know where they were located. Is that correct?
Yes, ma'am.
There was testimony that you had gone over to her home and knocked loudly on the door. Do you know what occasion she's speaking of?
That occasion was to drop off the medical records, or sorry, I can't say. I don't know if they're records, but the medical cards for the kids. That was banging. I didn't bang. I just knocked.
And did you have a conversation with her?
No, my intent is never to have a conversation. It's to drop stuff off and leave, so she doesn't feel like she's in danger or that anything else. It's just to drop stuff off and leave.
And you understand that that alarmed her.
Yes.
So in the future, do you think it would be wise to let her know if you were going to come over to her home?
Yes, ma'am.
I'll pass the witness, Your Honor.
All right, anything on redirect?
Nothing, Your Honor.
All right, so we're the first one to do the non-disclosure. There's no geo restriction in divorce.
I can check that, Your Honor.
Okay.
And I don't even know why I asked about the pickup and the drop off, because I don't even know that that was before the court.
Yeah, I think that's probably controlled by, they may be doing that by agreement.
So I need to apologize, Your Honor. I copied documents because I think the court knows our system is down, and the underlying the previous order, I don't have a copy of that saved.
I do. So the previous order does not have a geographic restriction. It says that Ms. Calloway can designate the primary residence of the children without regard to geographic location.
All right. All right, Ms. Calloway, based on that, ma'am, the fact that you could move, if it was a geo restriction, I would go ahead and grant the non-disclosure going forward. But because under that prior order, you can move anywhere you want to in the world, you've got that right. So I do need to go ahead and get the order that you do maintain, giving him that information if you decide
Yes,
to
sir.
move. Okay, all right. So I'll go ahead and grant that. And sir, what is your disability? What's your percentage of disability at this time?
100% PNT.
Okay, so you're getting a little bit more than 4K a month, right?
$80 more, sir.
Okay, then. And how long you think it's going to take you to get where you need to be to get become a full-time teacher again?
Full-time teacher, I don't know. So I was going to do appraising.
Okay, all right. I thought that was just part of the teaching thing, but you're looking at doing how long before you get your appraisal credentials ready to go where you can work full-time at that, sir?
So to work, it would be, I would say about August, because my last course is like sometime in July.
All right, then. Well, sir, I'm going to go ahead and do a snapshot in time and take care of this. I'm not going to make everybody come back after August. But if you do change professions and add professions, I will order that you let mom know and the state know within 30 days of any full-time employment. All right.
Yes, sir.
All right, then. But anyway, right now, folks, I'm looking at going ahead and making the order, the final order, the temporary order final. And the temporary order, did we set up? We do have app close set up at this time, or is that the last case I'm thinking about? Okay. Yeah.
App close is set up, I believe, through their divorce decree, Your Honor.
Okay, so going forward, everybody still has to do app close. I was going to do that just for the safety purposes anyway. I could probably get away with that portion alone. So everything y'all need to do y'all communicate through an app close, and that way it can be confirmed. But like I said, everything else I'm looking at going ahead and granting as far as the current child support I'm looking at making the temporary order final as far as this case is concerned. Is there anything specifically that the state needs me to rule on as far as anything as for the final order, Mr. Diamond?
No, Your Honor, I think it's all been covered.
All right, Ms. Gustafson, anything else from you, ma'am?
No, sir.
Okay, Mr. Calloway,
Yes, sir.
any questions, sir?
No, sir.
Ms. Calloway, anything else? Any questions, ma'am?
No, sir.
All right, Mr. Diamond, may the parties be excused, or do you want to back in breakout room to send them that information?
If they could be excused, Your Honor, it's going to take me a few minutes to get to this.
Good enough then. Thank you, folks. Good luck out there. Be careful. Take care of the two boys, right?
Yes, sir.
How old are they now?
6 and 8.
Okay, tell the 8-year-old, because I have a brother that I was 8, he was 6. I still can't get rid of the guy, okay? We're a lot older than that now, and we still hang out too much, okay?
Yes, sir.
All right, then. Tell him that's going to be his best friend. Sometimes he's going to forget, but this is his best friend for the rest of his life. He doesn't know it yet, okay? So
They love each other. They're good.
all right, good enough then. Thank you. All right, y'all take care, folks. And we're
Thank
off.
you, you too.
God bless you, sir.
Thank you.
Thank you, Your Honor.
Just don't let him borrow money from him, okay? Yeah, baby brothers have a tendency to like doing that. Okay.